Welcome everyone to today's webinar entitled Gucci Poochie Pepsi Lawnmowers. We'll be discussing IP, brand protection and business name changes and how this may affect your organization directly or the clients that you may assist. My name is Tyron Walker. I joined Hunt & Hunt at the beginning of this year and specialize in IP, brand protection, advertising law, website law and social media. Some of the international clients I've assisted over the years include Coca-Cola, Louis Vuitton, Samsung, just to name a few. I'm joined by Georgette Georges today.
Hi, everyone. Thanks for having me.
Thanks, Georgette. We'll be sending over the presentation over email after the webinar today, and the webinar is interactive. So if you have any questions, please feel free to send them through. If there's any specific questions, please send them over email, and we'll happily answer any questions that you may have about IP or your organization or your business name. The agenda today is literally we speak about what is IP, what is brand protection and trademarks, knowing your rights once you actually have a brand or a trademark protected, and how business names and trademarks relate to each other and what's the new impacts of the business name legislation that's just been passed, or a new updated case, I mean. Today's going to kick off and discuss brands and why they're so valuable, and break down a little bit about IP and brand protection, and more specifically focus on trademark rights.
Okay, so a brand is one of the most valuable assets that a business has. Recently, the Woolworths brand took the title of the most valuable brand in Australia, worth a whopping $16.2 billion. Telstra came in second, valued at $13.2 billion, with the Commonwealth Bank trailing behind, valued at $11.4 billion. Business owners are usually very keen to outlay costs when developing a brand, to make sure that the brand name and associated images, catchphrases, and colors are perfect for their purpose. Usually, significant resources are spent on acquiring a domain name and setting up a website, as well as marketing products or services to the public through this channel. However, unfortunately, it is not uncommon that businesses of all magnitudes fail to take the steps that are necessary to protect this significant investment, specifically by registering their trademarks. So, what is a trademark? A trademark is not simply a brand name or a word. A trademark is a sign that connects your business to the goods and services which it provides. It can be a range of things, such as a logo, a slogan, a name, letter, color, or shape. So why are trademarks so valuable? There are many reasons why trademarks are valuable business assets, a lot which are listed in this slide that I'll let you have a read of a little later on. For me, I'd like to pinpoint some of the standout reasons, which include: 1, they help your business stand out from the crowd as they identify and differentiate the business, product or service being offered. Through this differentiation, trademarks can protect your business and reputation. And 3, with registered trademarks, your businesses will be granted exclusive rights to use, license and sell the mark. And therefore, as a business, you are able to generate income through the licensing and sale of these trademarks. So, how do you protect your trademark? The best way to protect your trademark for the specific goods or services which you provide is to have it registered in any of the countries which your business provides those goods or services. But before applying to register a trademark, it is crucial that you first undertake brand clearance searches to determine whether there are any brands that are using the same or similar trademarks that you wish to register. Some of these searches include searches of the trademark register, the company name and domain name searches, and your general marketplace searches, for example, just a general Google search. These searches are extremely necessary for a range of reasons, particularly to determine: 1, whether there are any prior registered trademarks or applications which might stand as barriers to registration of your mark. 2, whether there is a possibility that the use of your mark might be infringing the pre-existing intellectual property rights of a third party. And lastly, whether by using the mark, there is a possibility that you may be engaging in misleading and deceptive conduct or passing off. So trademark selection is critical. There are certain types of trademarks which you cannot apply to protect via trademark registration, and therefore, careful selection of your trademark is absolutely critical. A trademark needs to be unique and distinctive. It cannot describe the product or service that's being offered, or be a common word, name, or phrase, or even a geographical location. Here are some examples of marks that were rejected for registration in Australia on the basis that they weren't distinctive. I'll let Tyrone go into detail with why some of the trademarks displayed here could not be registered.
Thanks, Rajat. Well, the key requirement is that it doesn't describe your product or service. And number of brands out there and a number of business names actually describe exactly what they do. And to be honest, that's not a great brand at all. There will be no value attached to that brand name. It needs to be unique. Good examples are Google, TikTok, Facebook. Now, some brand names and trademarks might have a connotation or might be a play on words to exactly what the product or service they're offering is. Facebook is quite a good example in that, there's a connotation that still, there's your image there, it's a representation of yourself, but it's a play on word, but it's still unique. So examples here like Brisbane Gin and Burrito are terrible trademarks, to be honest. Burrito was filed for food products themselves, and that brand, you won't be able to stop anyone else from trading with the name Burrito or using it on their product because it describes exactly what the food product is. Brisbane Gin, once again, obviously it's been produced in Brisbane and that's why they've named it Brisbane Gin. But now to go stop any other gin manufacturer that creates their gin in Brisbane will be very, very difficult. There's a couple of cases around the world where alcohol manufacturers haven't been able to actually trademark the geographical location in connection with their wine or their spirit, but it's very, very difficult. Yeah. Other examples are, say, a bathroom renovation company in Newcastle, and they've tried to trademark Newcastle Bathroom Renovators, and that's obviously their business name as well. But it will be difficult to enforce, and it kind of doesn't step you out from the crowd. And that's the whole point of creating a unique brand or identity, is one, to step out from the crowd, so that consumers actually remember your brand in the name, and there will obviously be value attached to that uniqueness.
Yeah, absolutely. So it's, I guess, very important that your trademark is unique. Okay, so on to trademark categories. So registered trademarks are classified into different categories. These are called classes. In Australia, you can only rely on the protection offered to a registered trademark in the classes of goods or services for which that trademark is registered. So, for example, if your business makes casual shoes, you should be registered in Class 25. However, being registered in Class 25 for casual shoes, 1, does not mean that through this registration you have a monopoly over all classes of goods and services, or 2, that you will be able to successfully stop another party from applying to register the same or similar mark in a completely unrelated class. For example, in Class 35 for real estate services. That being said, when you apply to register a trademark, you must carefully consider the classes for which you require registration and prepare class descriptions that are accurate and compliant with the class requirements. Generally, you should not apply to register your mark in any class which you do not currently provide goods or services or otherwise intend to provide these goods or services in the near future. We appreciate this can be a tricky process. However, this is something that we can assist you with once we know a little bit more about the goods and services which you provide and the future direction of your business. So, moving on to international trademark registration. A trademark that's registered with IP Australia offers protection in Australia only. If you're trading overseas, it is important to consider ways to protect your mark in those jurisdictions, as there is no such concept as a universal trademark registration. To register a trademark in an overseas location, You would need to file a trademark application in each relevant jurisdiction, and that application would need to be determined by that country's IP office. However, there are some trademark systems, for example, the EU Community Trademark System or the Madrid system, which allow for a single trademark application to cover registration in more than one country. However, this is only provided that the designated countries are all members of that particular system. So, if the country required is not a member of one of the relevant system, you will need to file a single trademark application directly with the IP office of that country.
Okay, so no, you're right. So once a brand's been created, you've done the clearance searches, you've applied for the trademark, the registration process, you need to apply obviously in each country that you're going to kind of intend to operate in or actually trade in. The registration process of a trademark can take anywhere up to 12 months or more, depending on the territory. So it is quite a process to get it registered. Once you've filed the trademark, you can use the letters TM next to your brand. And once it's actually registered, you'll see there is a little letter R with a circle around it that's used normally associated quite close to the brand. You can use the registered symbol. So what does that mean? So once your trademark's actually registered, you own the rights to the brand name or actually own rights to the trademark. And you will have an exclusive right to that trademark or to that brand name. So you can basically stop others and apply for an injunction to stop others in court to start using your brand name or your trademark. And you can actually get an award or an order for damages or delivery up of the products or documents that incorporate your trademark, and an award to pay to obviously claim back your legal costs. So we're going to discuss some of the trademarks that are already being taken in some of the territories. So for decades, companies with identical or near identical names have caused quite a few problems. When Burger King wished to operate in Australia in 1971, someone had a registered trademark for Burger King, which then gave them a monopoly to the name. It was a small takeaway restaurant based in Adelaide. The only option that the US corporation Burger King had at that stage was to either, one, buy the trademark from the owner or adopt a new name. They settled on the name Hungry Jack's and continued to trade with that name. Interestingly enough, the owner of the Burger King trademark allowed the trademark to lapse around the mid-1990s, and the Burger King Corporation in the US filed numerous amounts of trademarks to protect the brand and actually continued to use the Hungry Jack's brand. The reason for that is that they believe they built up enough goodwill and reputation in Hungry Jack's, and that was the reason for continued use of Hungry Jack's. They still have registrations for Burger King. They're still entitled to actually use the Burger King trademark in Australia if they wanted to do so. Other names which have been adopted differently in other territories include KFC. In Quebec, Canada, the law actually states that you need to trade with a French name. So KFC actually couldn't trade with KFC and actually trade with PFK in Canada. Other brands that are trade with the same packaging, they're owned by the same company, but called different things in different countries or different names in different countries include Lay's potato chips. I think they were previously called Smiths in Australia, but I might be mistaken. But in England, they're called Walkers. In Egypt, they actually Lay's are called Pokka in Vietnam, and Chipsy in Egypt, and Sabritas in Mexico. Another good example is Kellogg's with their cereal brands. They call their brands different in different countries. So here they're called Rice Bubbles, and in other countries it's actually called Rice Krispies, the certain cereal brand. We're going to chat about a couple of brand protection cases that have come about in the last year or two. The first one was the Better Beer case, which involved a dispute between two beers, Sidewinder and Better Beer. As we can see, the two beers packaging look very, very similar. I must point out at this time that actually food and beverage manufacturers and producers file trademarks to protect their packaging and the look and feel of their packaging. Winemakers will file a trademark for their label, and protect the identity of their wine label, which is quite distinct, and that's how you choose your wine when you walk along the shelves in a bottle store or liquor store. And Coca-Cola has actually protected the shape of their unique Coke bottle design. The Sidewinder beer was available for purchase actually 3 months before Better Beer. Even though the packaging looks similar, they both agreed that they actually conceived the packaging independently and weren't influenced by each other or adopted each other's packaging. Sidewinder commenced proceedings against Better Beer, alleging that consumers would be confused by the different packaging and would potentially buy the wrong beer. What was quite interesting in this case is that the judge actually stated that consumers know which beer they're purchasing. There's a vast amount of beer products out there, and they've got the knowledge of specifically what brand they want to go for and what type of beer. So they won't, a beer drinker won't actually choose a pale ale if they're going there to choose a lager, and they'll specifically choose the brand, and they're aware of the different brands, and they're quite picky when it comes to choosing. And that actually influenced the judge in this proceedings. And that's happened around the whole world, in that judges are finding that consumers aren't stupid, if I can put it bluntly. They know what they're choosing when they're picking their brands and actually purchasing products. And to prove actually confusion is becoming harder and harder. Other recent trademark cases was the real recent one of Katy Perry, the fashion designer versus Katy Perry, the musician. Katie Taylor, who sold her clothing brand under Katy Perry, won the trademark dispute against Katy Perry, the US musician. The fashion designer started her business in late 2006 and registered the Katy Perry brand as a trademark in 2009. She claimed to only have become aware of the singer in 2008 and wasn't really keen on her music. The whole dispute began when Katy Perry, the US musician, actually filed a trademark in Australia and later sent a cease and desist letter to the fashion designer, obviously requesting her to stop making use of the trademark. The federal court ordered that Katy Perry, the singer, actually infringed the fashion designer's trademark, but Katy Perry, the US musician, actually was able to successfully defend the claim based on the defense of using her own name. So you are entitled to use your own name on products or as a service, as long as that use is fair, and it's not against a really famous kind of well-known brand. So you wouldn't be able to adopt, say, McDonald's in this country and trade with a burger restaurant with the name of McDonald's. So you can make fair use of your own name, but it does apply to specific instances. The judge also went further, so granted Katy Perry the defense, so she wasn't entitled to pay damages to the fashion designer in her personal capacity, but her company was a different story. The company was found to have actually infringed by promoting and selling different clothing items, which obviously had the Katy Perry trademark on, and they will probably have to pay damages to the fashion designer. So Katy Perry, the fashion designer, still has a registered trademark in this country, and managed to actually enforce her rights. The next case was Optus versus Boost Mobile. In this case, Optus launched a new feature that allowed customers to get priority access to its network and higher internet speed for a couple of extra dollars. The feature was branded and used as Boost, Boost Mobile, Internet Boost, Optus Boost, or Mobile Boost. Boost Mobile launched urgent court proceedings here because they had a trademark registration for the word Boost. You might be thinking, well, Boost is a very descriptive trademark. Recently, or we just spoke in this webinar that descriptive trademarks are not unique, they're not distinctive, and a third party shouldn't have a trademark that actually describes the product or service offering. And obviously, Boost is a word that describes features of the internet and telecommunications. While Boost Mobile's had their trademark for quite a number of years, no one's attacked the registration, and Optus in this case also failed to attack the registration that it's actually a descriptive trademark. I'm not too sure why they didn't attack the registration. They should have. And they ended up losing this court case and had to remove Boost from all the feature and had to pay damages towards Boost Mobile. Optus states that the damages that they incurred will probably be in excess of $3.5 million. The next case is the Hells Angels versus Redbubble case. So Redbubble is an online marketplace that allows independent artists and designers to sell their artwork on a variety of products, such as clothing, phone cases, stickers, and home decor. The customers can browse the catalog that's on Redbubble website and select the images or designs that they want to place on the promotional items, and then order the promotional items, which then get delivered, obviously, to their home. In this case, Hells Angels obviously sued for trademark infringement. Their logo and image was on the Redbubble website and was placed on items, promotional items, and the court awarded that their trademark had been infringed, and the trademark and the images needed to be removed from the website immediately. The last case on the slide is also another interesting case. So normally you're not entitled to obtain protection of a name. So in this case, Henley, in an ordering course, you wouldn't think Henley would be able to be trademarked because a number of third parties would need to use the name Henley or have the surname Henley and trade with the surname Henley in their business. But in this case, Henley Arch actually had a trademark registration or a number of trademark registrations for Henley and managed to stop Henley Constructions, which had been trading for quite a while, from using their trademark and their name. Henley Constructions even had a telephone number which they traded with and advertised on various items and on the website 1300 Henley. And the court awarded that they had infringed their trademark by using Henley in the telephone number. We always say, don't forget the net. A domain name will identify a website on the internet. So it consists of two parts, one being the main brand or the product name, and the second part will actually be the geographical location, so the .au or any other country in the world, say it's .co.za, .co.ng, or designate certain countries in the world. So the problem with domain names are that they come on a first come, first served basis. So you can go, any third party or any person can go register a domain name now, and whatever name is available, you can register it. So if mcdonalds.com.au is available, you're entitled to go register it. Whether you actually have rights to that domain name is another question, and that could be a dispute later on. But I've listed a couple of examples here where there are obviously companies with the same name. And Gap Robotics is obviously a robotics company or electronics company, and there's Gap Clothing, which was actually a client of mine. And they're both entitled to use the name Gap. They're both in different product or service offerings. So companies can adopt the same name as long as that name's not famous, and there's a few other caveats to it. But in this case, no third party or no consumer would be confused in the existence of Gap Robotics and Gap, the clothing company. The problem comes when who actually owns the rights to the domain name. So in this case, gap.com.au is actually owned by Gap Robotics. Gap, the worldwide fashion retailer, will probably be more well known to individuals on the streets, but that doesn't mean Gap Robotics isn't entitled to the domain name and to the fair use of the domain name, and Gap Clothing wouldn't be able to do anything about it. So Gap Clothing had to go and register gapaustralia.com.au as their domain name and their website that users can go onto. Other examples there are Nissan.com. So Nissan, the car manufacturer, actually doesn't have the domain name registration Nissan.com, which you might find that's quite bizarre. But like I said, anyone is entitled to go register a domain name. You can go register Nissan.com. The point is that you need to have fair use and be able to see if you're actually legally entitled to the domain name. If you make use of a brand or a product with Nissan, it's not in car manufacturing services. Maybe they manufacture pipes for plumbing, then they would be entitled to Nissan.com. When you access this website, it's actually it's pretty much a blank page at the moment, which will be interesting to see what happens in the future. CadillacAustralia.com.au is another example where Cadillac actually had to lodge a domain name dispute against the third party that had registered this domain name. So kind of discussing that further, if a third party does register a domain name that they're not entitled to, you are entitled to lodge a domain name dispute. So it's a court objection to the domain name and actually gain that domain name back. We'll discuss the value of the domain name. So third parties do register domain names and actually sell them. They're pretty much well known as cyber squatters, some of them, which are third parties that go register the domain name with a view to kind of making money out of it and selling it back to a business or a different business that might trade with a similar name. So as you can understand, there's a number of safari companies out in the world that offer wildlife services, but only one person will be entitled to register the domain name safari.com. It's like the news.com.au is another domain name, Channel 9 News or 7plus News. They would all be entitled to go register that domain name. It would really be who registered first. So how do you value a domain name? Well, it depends on a couple of factors. One, the length. The shorter the domain name, the more valuable it is. So a domain name like abc.com or abc.com.au will be very, very valuable just because it's short, it's easy to type in, and it can be remembered by the consumer. Other examples of short and very valuable domain names will include news.com, surf.com, capital.com. It will also depend on the extension. So a .com will be more valuable than a .com.au because obviously that is a top level domain name, and third parties and companies would like that domain name always as a first registration. These are a couple of examples of domain names that have sold for ridiculous amounts of money. The first is cars.com, was sold for $872 million in 2014. It was originally purchased by somebody for $2.5 million in 1998. Another discussion we need to have is around you're entitled to register descriptive domain names. So if you are a car salesman or you own a second-hand car dealership, you are entitled to register a generic, a descriptive, a common domain name. You might not be entitled to apply and register a trademark for car in car services, but you would be entitled to register the domain name. So there's a slight subtle difference there between a trademark and a domain name. Other examples are insure.com, was sold for $16 million, where it was originally purchased for 1.6. Vacationrentals.com was purchased for $35 million recently by a company. And privatejet.com was sold for $30 million in 2012, even though it was bought in 1997 for $9,000 and held on to. Jumping back to what I previously said, domain name complaints. So if somebody registers a domain name or your company's business name or your trademark as a domain name, and they're not entitled to the registration of the domain name or the website, and they've registered in bad faith and they're possibly diverting any kind of web traffic to their business or unrelated business or product or service offering, you're entitled to lodge a domain name dispute, which we can help you with. Amazon Books is a big domain name complaint filer, and so is many of the major brands in the world. They enforce all their rights in terms of their trademarks and domain names. A good example of a recent big domain name dispute was Madonna. She fought and managed to obtain back her Madonna.com domain name. I've put Google on the slide there because it was quite interesting. A lot of brands forget to renew their domain name. So once you've actually registered your domain name and your website, every year or two it needs to be renewed depending on the domain name. And there's a rumor that Google.com actually forgot to renew their domain name, and somebody snapped it up and Google had to go back and purchase the domain name back from them. I've got two other examples at the bottom, which are a domain name hippo.co.za and numetro.com, which I actually worked on. And they're interesting because hippo.co.za, there was a misspelling registered, a domain name misspelling. So if you see there, it's spelled HIPOO. So a lot of misspelling of brand names are actually registered by third parties or these cyber squatters. They or a nickname called domain name pirates, and they will register the misspellings on the fact that you might type it incorrectly. So the letter P and O is very close by on the keyboard, and often mistakes happen when you enter in a domain name. And this Hipu website actually reverted to a pornographic website. And the insurance client that I was acting from were obviously disturbed about this, and we lodged a domain name dispute and were able to get the domain name back. The numetro.com domain name was another example where they actually forgot to renew the domain name. They lost the rights to the domain name. It was snapped up by a domain name pirate or one of these cyber squatters. And the clients had the option of, obviously they had trademark rights. They could enforce those trademark rights by lodging a domain name dispute, obtaining the domain name and the website back from this third party. But we went another route here in that we actually approached this third party and offered them an amount, because it would be quicker to offer an amount on an anonymous basis and purchase the domain name back from them, then lodge the dispute and go through the proceedings, which would take maybe 2 or 3 months. The domain name and the website was obviously the first port of call for the revenue generation. So they needed it back as fast as possible. And we were able to actually secure that domain name back by purchasing it back from this third party domain name pirate.
Wow, Ty, just before you go on to the next slide, when it comes to lodging a domain name complaint, who's the authority that you do that with? How is that done?
So it depends on the domain name and obviously the extension. So separate territories do have separate domain name dispute bodies that you've got to lodge them through. There is an international organization that you can lodge the .coms and the .nets through, but it will depend on the specific domain name and the territory.
Okay.
So we will speak quickly about social media. Social media is obviously a big talking point when it comes to legality. When you've created a business name or identified a new product that you might launch, we always say register the social media accounts, the various Instagram, Facebook, TikTok accounts, because they are also registered by these pirates or cyber squatters to try and make money out of. But saying that, there are obviously always social media pages that pop up that kind of pass off or rip off your clients' products or brand names or potentially your business name. A good example that I've quickly picked up now is for Gap. Obviously, there's an Instagram account that's very similar to their name and their brand and use a similar logo. And I've assisted them in the past with lodging various disputes against these social media accounts. And another example here is for the brand Nando's. Obviously, there's a third party that's trying to pass themselves off and also opened up a chicken restaurant and then called themselves Chicken Nando's. So they would be entitled to lodge a dispute against these third parties and obtain the social media pages back from them or get them deregistered. To speak about a few of the celebrity trademark cases out there. So celebrities actually protect their name. They'll file a trademark for their name. Most celebrities and sports persons do it around the world. So somebody like Oprah Winfrey will file a trademark for her name in every country around the world. Ellen DeGeneres is another one, and a lot of the musicians. On a side topic, Beyonce, when her son, I think it was when her daughter was born, Blue Ivy, she filed a trademark immediately for her daughter's name on the date of her birth. Around the whole world, she filed a trademark for her daughter's name, Blue Ivy, just to secure those rights and not run into any kind of problems. The benefit of a trademark is once it's filed and registered, it does last for 10 years, and then you can renew it every 10 years. So you'll have rights to a trademark or a name indefinitely, and hence why Beyonce went and filed Blue Ivy around the world. But jumping back to these celebrity cases, there was the battle of the Kylies, Kylie Jenner versus Kylie Minogue, where Kylie Jenner obviously applied for her trademark for the brand Kylie. She was launching the cosmetics brand around the world. And Kylie Minogue opposed the trademark registration and believed that consumers would be, well, number one, believed that she had rights to the word Kylie and the brand Kylie, and that there would be confusion based on the two brands. The two ladies did later enter into a settlement agreement. I'm sure there was some nice money made by Kylie Minogue, and Kylie Jenner was entitled to her trademark and allowed to register a trademark and continue to trade with the trademark. Other cases include Ian Thorpe. Ian Thorpe launched the brand Thorpedo, which is well known by, obviously in terms of his swimwear and clothing and swimwear range. And a company that was trading with the name and had the trademark rights to the name Torpedo opposed the trademark and obviously its use. And quite interestingly enough, there was a debate on confusion that would exist in the marketplace, and the judge came to the opinion, briefly saying that he came to the opinion that there wouldn't be confusion. Torpedo was so well known in Australia that consumers wouldn't be confused with the two brands coexisting or Torpedo existing. Funny enough, the original Torpedo trademarks actually lapsed, it's fallen away. So Torpedo will have exclusive rights to that brand and any similar brand going forward. The last one was Rihanna versus Topshop. So the UK fashion retailer Topshop launched clothing items with Rihanna's face all over it, and Rihanna obviously launched injunction proceedings to stop Topshop from selling t-shirts with her image and her brand on it. And Topshop sold 21,000 t-shirts roughly with the image, and Rihanna successfully enforced her rights and was awarded damages in that case. Now jumping to business name registrations and how this will affect your organization and obviously any of your clients' organizations. Now, obviously every entity that trades will have to have a business name registration, but there's been a recent case, and it was the case of Elevate Education versus Elevated Learning. And the one was a company name and the other was a business name registration. Both entities traded in the same or similar products and services. So I'm just going to repeat that again. It was Elevate and Elevated were the two brands. So Elevate Education and Elevated Learning. They were very similar in terms of the only difference really in the Elevate, which is the main kind of dominant portion of the brand, was the additional letter D. Now, the new ruling that's come out has stated that basically the business name registers, they can only make rulings or objections, they can only uphold objections that are identical to the name. So if your client goes, or if you register a business name on for your clients and you apply for it and it's available, it doesn't necessarily mean it is available for a couple of reasons. So one, when coming up with a new business name or registering a business name, the business name registry doesn't do a cross-check of the trademark database. So you might register a business name, but the trademark might not be available. Somebody else might have registered that trademark. So if I've come up with the brand Squirmish for sponges, and I actually register the business name Squirmish Pty Limited, and it's available and I get the registration, and I haven't done a check on the trademark database, it might not mean the brand and the business name is actually available. Now, going back to the same company name and business name, which happened in this dispute, the business names will only be rejected when you apply for the business name. It will only be rejected if it is identical. So if Coca-Cola Pty Limited have registered their business name and I go apply for Coca-Cola Pty Limited, it will be rejected. The computer database, the computer program that's actually accepting the trademark registrations will kick it out, will reject the domain, it will reject the business name registration. But if I go register something similar, the computer program that's accepting the business name registrations won't reject anything that is similar. So a couple of business names, or not a couple, or many business names are actually being registered, even though there might be trademark rights attached to that business name or a trademark that's in existence, or actually a similar company or a similar company name that's been registered. So I've listed a couple of examples here. So Coca-Cola won't have a business name most likely for Coke Pty Limited. They'll have the trademark Coke registered, but a business went and registered Bowen Coke Pty Limited. The same might be for Pepsi. I would think Pepsi would have a business name registration in Australia. They will definitely have numerous trademark registrations, but because the computer system is not rejecting similar or near identical business name registrations, third parties are able to go and register those similar business names. So Pepsi lawnmower business, Nike plumbing, famous names like Nelson Mandela have been registered as business names. So your client may have a business name registered, but if they don't have that trademark to actually have trademark a registered right against it, a third party can go and register a similar business name, and they won't have the trademark rights to go and enforce and stop that business from trading and actually having the business name registration. They would have to rely on what's known as passing off, which is their common law rights and their reputation that they've built in that business name, which is very, very difficult to prove. You've got to prove that consumers in the marketplace actually identify your company name or your business name with the product or service offering. Whereas if you have a trademark, you can just rely on the trademark rights. You can hold up the trademark certificate or attach it in the court papers and ask the court to make an order that the business name be rejected based on your trademark registration. I hope I've explained that simply enough. It's a bit of a, I don't know, Georgette, have I explained it simply enough?
Definitely. And sorry, just to jump in here, this kind of all ties back with what we were talking about in terms of searches and making sure that you do the searches of all the registers, you know, and making sure that this is done before you make that decision or you pull the plug and say, yeah, this is the name of my brand, or this is the name of my company. So these are all really important things that need to be looked at, I guess, you know, in the beginning of the process. You don't want to be in a situation where you've created your brand, you've spent a lot of money on your marketing, you know, and then you've registered a business name, you spend all this money, and then all for someone to come and be like, hey, you can't use this name because I've got a registered trademark and I've been trading for a long time.
Yeah, so going back to this recent case in the tribunal, so basically the tribunal said that they can't make a common sense approach decision to the similar business name, even though Elevate and Elevated is nearly identical. We can't dispute that. They said they don't have the authority. The kind of regulations that are out there at the moment are very restrictive. They're constrictive. They can't make a subjective or a common sense approach to the decision, even though they might be nearly identical. The legislation that's out there has stated that it needs to be basically identical in order for the tribunal to agree that there would be confusion and they need to reject the business name, which doesn't make sense. Obviously, the legislation and the determinations that are out there need to be updated. So a third party can go register a similar business name to yours or your clients. Hence why I say you need a trademark registration. Every company, like having a business name registration, should have a trademark registration. And if your client is adopting a new business name or you're registering a new business name on behalf of your client, you should be doing those trademark searches first, checking if there is the trademark available. So I hope that explains it.
Yeah, absolutely. And you don't want to somehow then all of a sudden be on the other end of some litigation or some dispute before you've even kicked off your business, especially if you're a startup. Things can start to get very expensive very quickly.
And another question might be, well, why are these business names currently on the database? So why is there Nike Plumbing? Why is Apple Telecommunications? Why is Barack Obama there? Well, one, they obviously haven't been alerted to it, or they might be in current litigation proceedings, or their lawyers that represent them haven't picked this up. So Hunt & Hunt conducts searches on behalf of their clients, specifically their trademarks that they've registered for their clients. We conduct continuous searches both on the trademark and the company and business name registries, databases, and we look for this identical or similar business names and trademarks that are being registered, and we'll alert you to those, and obviously we'll have an opportunity to object to them.
And Ty, with that, how often do you think people should be kind of having a look at what's out there and just seeing, doing a general search, hey, is there anything similar to me out there?
Look, we will do that on behalf of our clients, but often the first port of call which we found is that customers of the business will be like, well, I've bought a product, or I've seen a different service being offered on the internet, or I got confused with this Facebook page. So it's often the consumers or your actual customers that will pick up something and alert you to it. If they do alert you to a possible infringement, then you should contact our offices.
Yeah.
So kind of going back, we say you should protect your business. So in order to protect your business and have exclusive right to that business name or the company name, register the trademark, make sure the domain name and social media pages are registered, and you can stop others from using it. So even if you're in a construction business and you don't think that you're ever going to use a social media page, it doesn't stop you from going and registering the social media page or the domain name. It's better just to have registered. You don't ever have to use it, but once you've done it, you'll secure it, and then no third party will go and register it and maybe post something that's inappropriate on it, like the pornographic website on hipu.co.za.
Okay. Well,
if you like, yeah.
Yeah, sorry. No, that was just going to say that was really interesting, and all those real life kind of celebrity examples are very interesting. We had, off the back of your celebrity example, we've had a question come through, which I think is pretty interesting, given this rise of AI generated images. So someone's asked, given the rise of AI generated images, would you expect celebrities to also trademark their face or likeness?
Yeah, so celebrities do. They try to do as much protection as they can when it comes to their likeness or their face. Some celebrities around the world have trademarked their likeness, in different forms. Nelson Mandela would have protected his name in various ways, especially with his famous face. But different territories and different countries in the world have different rules or legislation around actually protecting their likeness in the face. In Australia, you got to rely on passing off, and you got to rely on consumer law in terms of enforcing your rights. So certain celebrities can. It just depends on the legislation of that country in terms of the protection. But there's celebrity cases all the time. Majority of them do win. The whole generation of AI images around celebrity images is quite an interesting one. The AI has opened up another whole in terms of intellectual property, and we'll probably have an upcoming webinar on that, and how you can protect yourselves, and how celebrities protect themselves, and how businesses can protect themselves in terms of AI, because obviously there is certain intellectual property that is being infringed with all the AI generation. But yeah, jumping back to the Redbubble case, that just kind of shows that, if a celebrity image or a trademark or an image of a logo is utilized and Topshop is utilized on promotional items or clothing, you do have rights to enforce, and you could stop others from making merchandise and passing off or ripping off trademark rights or image rights.
I guess, and in terms of our current law, I mean, it wouldn't be silly to assume that coming later on down the track might be some reforms to law to account for all this new AI technology and things like that, in terms of trademark infringements and passing off and misleading and deceptive conduct, right?
Definitely.
Okay, well, I think we've got a couple minutes left, so maybe we'll just open the floor up for a minute or two just to see if anyone has any questions before we finish this seminar. So if you have some questions, just pop them through the question box, and we'll answer them on screen.
So another quick example is you might be thinking, well, our business has been around for 25 years. Why do I need a trademark? So once again, stating just because your entity or your business has been trading, or your client's business has been trading for 20 or 30 years, doesn't mean that it shouldn't have a trademark. Doesn't mean that others won't try to copy the trademark, won't try to copy your business or the idea or the concept behind the business. So you should always still, trademark costs are they're inexpensive. Once again, the rights last for indefinitely. The renewal costs and the application and registration costs are very minimal. So one should just have that. It's a part of compliance that a business should have.
Absolutely, and it seems that it is overlooked a lot of the time with companies or businesses that have been running for a long period of time, like 25 years or 30 years. It was never thought about back then, and then they build up a reputation where they're really well known, so they think, oh, hey, I don't need it. But then all of a sudden, some random, Joe Blow comes and registers their name as a trademark, and then all of a sudden they've got this dispute on their hands, and they've got to try and jump in there and figure out how they can get it. And if that cost was outlaid in the beginning, they'd be saving a lot more money, I guess, than having to fight it later on down the track. Okay, so another question that came through is about domain names. So you've got, for a domain name, would you have to register a .net or a .com.au separately? Are they separate registrations?
Yeah, so they're separate registrations. They're very simple to do. But for each domain name extension, you need to register it. So if you want georgette.com, you need to register georgette.com separately. If you want georgette.com.au, that's a separate registration. Georgette.au is a separate registration. We can do that on your behalf. Once again, domain names are also very, very inexpensive. A couple of $100 and you can get a registration. And it lasts a year or two depending, and you can renew it every 2 years. So I would recommend especially the .com.au and the .au. If you don't have those registrations, register them. If you're able to get the .com, that's amazing. I would definitely register that. Whether you go register all the other variations, .net, .org, .info, .co, there's thousands of different variations that have come out and extensions. They've even got .insurance, .finance, .bank, .accountants, .auditors. Wow. They've all come out with different extensions, so you can have your brand .accountants, or we can have Hunt and Hunt .law or .lawyers. Those extensions have become available. It's really up to your choice. Some companies wish to register every different variation they can. Others go, well, we'll register a couple of the main ones and we'll take it from there. So it's really a personal choice and obviously a cost, and we can give you the costing in terms of the domain name registrations. And
last question just from me. Am I right in saying, or maybe I'm wrong, that the .au is just a new handle that's come about lately?
Yeah, so .au is a new handle. I would definitely recommend you go do that. It'll be interesting in time whether, everyone likes everything short and sweet, short and simple and to the point. So it'll be interesting whether .com.au falls away in time and everyone just reverts to .au. From a branding perspective, some people might just like the look and the feel of .au because it is short and easier to advertise. So yeah.
And would you be recommending that clients that have a .com.au then go ahead and register the .au?
Definitely.
Because then there'll definitely be some confusion if someone else was to get the .au, right? Definitely. Yeah.
And avoid a dispute. So, if somebody goes and registers, say the company is this Henley, if they go register henley.au, to go incur all these expenses and stopping other people from using your trademark or your domain name, compared to the couple of $100 cost to file a trademark or a domain name, you would rather go and do that than incur thousands of dollars in terms of litigating against a third party.
Interesting, very interesting. Okay, any other questions that we've received? We're going to have to wrap up now, but we're happy to handle them offline. If you're able to just send us an email, our contact details are on this webinar. Please do, and we'll be able to help.
Perfect.
Anything else to say, Ty, before we log
No,
off?
we've got one late question coming through about sale of an asset. So a trademark can form part of a sale of an asset and whether it's fallen apart. Sorry, this anonymous attendee, you're more than welcome just to pop me an email. I'll definitely answer it for you.
Okay. All right. Well, thank you everyone for attending. We hope you found this informative. And please feel free to contact us if you have any questions.
Thank you, everyone.